Well, today is when the Baba Ramdev contempt hearing was scheduled before the top court, and just a day ahead of that, we saw a flurry of advertisements being issued by Patanjali Ayurved across various national dailies, 67 to be specific. And in these apology advertisements, Patanjali Ayurved importantly had expressed regret at its conduct for continuing to publish ads despite the Supreme Court orders restraining them, had said that it respects the dignity of the court as well as constitutional principles. Now, what's important are a couple of issues which the Apex Court raised, predominantly on how prominent these ads were. First up, the Apex Court asked whether these ads are prominent enough, whether one would require a microscope. That's what the Supreme Court said in jest. Further going on to say that if these advertisements which are apologizing are as big and as prominent as the ads which publicize the Patanjali products, at one point the counsel for Baba Ramdev responded by saying that these advertisements have cost lakhs of rupees, but here the Supreme Court observed if these lakhs of rupees add up to the amount that was spent on Patanjali advertising its own product. So these are questions that Baba Ramdev and as well as Patanjali will have to respond in the space of the next 1 week. Second, the Apex Court has sought to widen the scope of these proceedings and said that it's looking to look at the larger issue of misleading advertisements, is looking at a wide set of stakeholders. First up, without directly naming any company, the Supreme Court observed that it is looking at not just one entity, which is Patanjali Ayurved, but is looking at the much wider space of the FMCG companies, saying that there are a number of companies which are moving in that same direction of issuing misleading advertisements, companies that deal in products with respect to babies and for children, and this is something that the Apex Court has seen very recently, that this is something that the Apex Court is concerned about, and therefore is something we'll be focusing on going forward with respect to the conduct of the entire FMCG space. Not just that, on the conduct of the central government. Here, the Apex Court has raised the question that as far as central government is concerned, it will have to respond as to what actions it has taken to combat misleading advertisements. One pointed question that is, however, being asked by the Apex Court is, why was the provision under the Drugs and Cosmetics Act, which had in fact placed restrictions on advertisements of Ayurvedic products, why was that restriction withdrawn in 2023? That's one of the many questions that the centre will now have to respond on. Beyond the Ayush Ministry, the Consumer Affairs Ministry, the Ministry of Information and Broadcasting, and the Ministry of Electronics and IT have now also been made respondents. And finally, the question being raised against doctors here as well. The Apex Court saying that while the IMA, the Indian Medical Association, is pointing fingers at Patanjali Ayurved, there are fingers pointing back at itself as well. The Supreme Court observing that there are allegations of unethical practices by doctors receiving quid pro quo from pharmaceutical companies and then going on to recommend and prescribe their products and medicines and treatments, and that is something that the IMA will have to come clean on, will have to clarify before the Apex Court as to what actions are being taken to combat these unethical practices. So clearly, the Apex Court expressing its discontentment with the issue of misleading advertisements and looking to take action across the board for various stakeholders.